The Supreme Court, led by Chief Justice Earl Warren between 1953 and 1969, contributed to as striking a change in the way we think about American culture as any court in American history. It moved America away from a dominant view of a monolithic and homogeneous society into one in which the prevailing picture of a diverse society has been accompanied by a pluralistic or multicultural value system. This rather packed statement of the influence of the Warren Court is meant to capture two separate dimensions of its reimagination of American culture. The first is the descriptive. Lying behind most important judicial utterances is an implicit and perhaps only barely conscious picture of various aspects of American culture. Whether it is as simple as a rising or a falling crime rate that may explain criminal justice decisions, or the court's attitude towards capital punishment, or as complex as whether there's a real and substantial threat of social disorder or a danger to family values or to national security, most court decisions are based on some inchoate picture of the arrangement of American society. This picture, though often highly idealized or ideological, is usually incorporated into legal thought and experienced by judges as the way the world is, not as the way it should be. A second dimension of the judicial imagination of American culture is explicitly normative. For our purposes, it can be summarized as the degree to which courts believe that a diverse or pluralistic society is good or desirable, or, on the other hand, the conviction that a more homogeneous society is necessary in order to preserve order, or to prevent social anarchy, or to promote cherished values. Some of the decisions of the Warren Court moved us to re-experience society as more diverse and varied than we once thought. Other decisions led us to reconsider the value of homogeneity and take positive satisfaction in the diversity of a multicultural society. So let me begin with the second normative dimension. 2 decades before the Warren Court began, the Supreme Court decided the flag salute cases, which offer as clear example of a cultural paradigm shift as any in American history, in American constitutional history. In the first flag salute case, decided in 1940, the court, by an 8-to-1 vote, upheld the right of a school board to expel Jehovah's Witness children who had refused to salute the American flag on the grounds that it violated the biblical injunction against worshiping graven images. 3 years later, the court reversed its decision and by a 6-to-3 vote, struck down the compulsory flag salute. The first case was decided as the Nazi threat to take over all of Europe seemed about to be realized. The second case was decided after Pearl Harbor as the United States joined the battle against the Axis powers. Both cases were about patriotism and the cultural symbols necessary to sustain patriotic loyalty. In the first case, the court hardly paused before upholding the flag salute as a legitimate means of inculcating patriotic values. In the second case, the majority, over a passionate dissent by Justice Frankfurter, emphasized the differences between the coerced uniformity of the Nazis and the desirable diversity of a free society. It was the first time, I believe, that the court has ever identified diversity as the basis for loyalty and patriotism in a free society. Now, that this shouldn't have happened until the flag salute cases should come as no surprise if you actually begin to think about American history. If one looks to American political thought, one is struck by the dominance of the view that a homogeneous society with very similar values is most conducive to free government. Classical Republican theory had emphasized that only in a small republic like Machiavelli's Florence or Rousseau's Geneva could you produce free government, because homogeneity of values, they thought, and social condition could only be maintained over a small area. Jefferson's ideal republic of yeoman farmers was self-consciously modeled on classical Republican teachings. Now, moving fast forward 1 century, we see that a similar idea prevailed in the reaction to the mass immigration between 1880 and 1920. American institutions reacted by proclaiming the ideal of a melting pot in which the mostly Catholic and Jewish immigrants from Southern and Eastern Europe would be assimilated and integrated into the dominant white Protestant culture. It wasn't simply prejudice that produced the melting pot ideal. There was also the view that immigrants came from societies that had inculcated authoritarian and anti-democratic values. The second flag salute case, in reaction to the horrors of totalitarianism, broke with the classical view that cultural homogeneity was the necessary foundation of free government, and that the symbols of patriotism and loyalty should be deployed to produce such homogeneity. There are many other examples before the Warren Court era of the gradual emergence of pluralism as a cultural ideal. In philosophy, I think it was William James, the philosopher, who offered a pluralistic picture of the world, as much descriptive as prescriptive in his varieties of religious experience. During the 1920s, his student Horace Callan sought to develop a justification for cultural pluralism in opposition to the melting pot ideal. In England, at the same time, the political philosopher Harold Laski attacked the idea of a monistic parliamentary sovereignty with a theory of pluralism based on the development of private groups and associations, especially labor unions. But I think it was during the Warren era that the Supreme Court developed a more pluralistic picture of the world and a normative defense of it. Now, before I elaborate, it's important to introduce one qualification. Most of the decisions that acknowledge the cultural distinctiveness of minorities based on race, gender, religion, ethnicity, or sexual orientation appear after the end of the Warren era in 1969. For example, there are no cases during the Warren Court that address the discrimination of women or gays. Even religion cases, the most translatable into tests of tolerance for unconventional cultural minorities, are relatively few during the Warren era. Even questions of race, which I'll say much more about later, which dominate the Warren Court, beginning with Brown versus Board of Education, require some qualification based as they are on the ideal of assimilation and integration of blacks into the white mainstream. Nevertheless, if we look for the moment in which cultural difference came to be widely respected in American law, the Warren Court era broke substantial new ground. So before I continue, I just want to talk to you about a problem that I'll call the problem of translation. When I talk about the religion cases, as I just briefly did, we can easily translate from respect for minority religion into respect for cultural pluralism or diversity. So the religion cases, as I'll show you more in a moment, present a fairly easy, unproblematic way of translating from legal decisions into views of cultural diversity. But as I get more and more into other areas, the problems of translation become greater and greater because it's not clear, since the court often doesn't explicitly talk about whether it's in favor of cultural diversity or in favor of cultural pluralism, it's more difficult to translate from the legal decisions into their picture of culture. And so I move from that which seems to me the easiest to demonstrate the commitment to a pluralistic society, from that to those that are more problematic in terms of their translation, though I believe they're all, when you put them together, part of a similar pattern. The most important religion cases of the Warren Court struck down state-designated school prayers. The most famous of these cases, Engel versus Itali. Like the second flag salute case, the court appreciated the dilemma of non-mainstream religious minorities that not too long before were excluded from the court's picture of the relevant audience for school prayers. The court was attentive to the coercion that school prayers imposed not only on non-Christian religious minorities, but also, I think for the first time, on non-believers. By contrast, school prayers were originally instituted for the purpose of assimilating not only Jews and non-believers into dominant Christian culture, but also for the purpose of using the public schools as a way of spreading the Protestant view of the world to newly arrived Roman Catholics. In this respect, it is important to remember to what extent Catholics were cultural outsiders before JFK's election in 1960. There were no Catholics on the court between the time Justice Frank Murphy died in 1969 and my hero, Justice William Brennan, was appointed in 1956. At Justice Brennan's confirmation hearing, he was asked what no Protestant would ever have been asked, whether his religious views would affect his interpretation of the Constitution. The other important religion case of the Warren Court is, though it's not a constitutional case, but a case of statutory interpretation, is Seeger versus United States, the folk singer Pete Seeger, who sought conscientious objection from the Vietnam War. Though the statute that he was seeking conscientious objection under had clearly been written to privilege mainstream religious observance, the Judeo-Christian tradition, the Warren Court, in fact, refused to limit it in that way, extending it to non-institutional anti-war religious convictions. Another view of the gradual notion that it's not mainstream religious conviction that is only entitled to constitutional protection. Another move on the road towards the conception of a more diverse and pluralistic religious community. Now, the series of Warren Court cases dealing with citizenship are perhaps the most important expression of the court's new vision of cultural pluralism. The legal question before the court was whether Congress could deprive an American citizen of his citizenship rights for voting in foreign elections or serving in a foreign army. And the court held for the first time one of the really least appreciated major decisions of the American Supreme Court, held for the first time that it was unconstitutional to punish a citizen by revoking his rights of citizenship. The Warren Court held for the first time that the rights of citizenship were not revocable. Now, the Warren Court citizenship cases present a rich tapestry for understanding our changing conceptions of the American community. The citizenship cases offer a deep insight into the court's views on loyalty and disloyalty. For the first time, the court recognized that dual citizenship might not be inconsistent with loyalty. As Michael Walzer put it in Spheres of Justice, we all have multiple spheres of loyalty in a world of overlapping and not necessarily inconsistent loyalties. The monolithic picture of loyalty suggested by the first flag salute case is decisively rejected. Now here again I want to pause over the issue of translation. When lawyers or law professors read the citizenship cases, they may never even notice that it involves a question of a picture of American culture. After all, the formal holding of the citizenship cases is that the government has no constitutional right to revoke a person's citizenship. And that, on the face of things, seems not to have anything to do with the questions we're discussing today. But as you peel away the onion of the citizenship cases, you begin to see that first, obviously, the cases are about the issue of dual loyalty. And second, that the Warren Court has an idea of the rights of citizens that includes multiple and overlapping conceptions of loyalty. Then when you think about loyalty in the terms I've tried to get you to see it in the flag salute case, you begin to realize that the loyalty issue is the issue of whether you need a homogeneous society in order to produce a loyalty and patriotism. And there, as you begin to put it all together, you see once more that the Warren Court's picture of what produces patriotism and loyalty is not, as it traditionally had been, the view that a homogeneous society is the best foundation for a loyal and patriotic citizenry, but rather that diversity and pluralism is. So again, I'm really trying to show you how the issues of translation are different from the way we talk about them today. Today, if we were talking about multiculturalism, we would talk about race, gender, ethnicity, and how did the Warren Court decide these cases. But except for race, there's almost no example of that in the Warren Court. You rather have to look to other areas in which a much more implicit picture of the world is emerging, which becomes the basis for the gender, sexual orientation cases that we study later. Now, another reason why we don't ordinarily think about it the way I'm putting it to you is this. We've been taught to think about the Warren Court cases that we think of as laying the foundation for the future multicultural world as rights cases. And so it would be typical of a lawyer to say, yes, the Warren Court laid the foundation for the protection of cultural minorities through its protection of rights. But I believe that that just begs the question. Rights talk doesn't yield necessarily determinate answers. That the Warren Court thought of protecting the rights of cultural minorities was not because it believed that a conception of rights logically required that, but rather because it used the conception of rights to express this cultural point of view. Now, I just want to underline this point. Rights as a conception has been a multi-splendored thing. Rights ideas in American history have not always favored the weak, the disadvantaged, and the oppressed. Though in the Declaration of Independence we hold these truths to be self-evident, was clearly a revolutionary statement of rights. For the next 50 years after the American Revolution, rights talk is mostly about one right, and that is protecting the right of property. Even if you look to the next phase in which a liberatory conception of rights emerges in American society, and that is in the abolitionist movement, you will see that there was as much rights talk in defense of slavery as there was in opposition to slavery. Because slavery, after all, was property, because property had a whole elaborated idea of protection of property rights. And so, interestingly enough, if we go fast forward to 1940 and we ask, what did most progressive reformers believe about rights? The answer, remarkably enough, is that they basically believed that rights ideas were reactionary, because in American history they observed most invocation of rights was in favor of the defense of property. Now that all changed after the Second World War, the emergence of rights, the emergence of the Universal Declaration of Human Rights, the idea of international law as protecting rights in the Nuremberg trial, the reaction to the horrors of totalitarianism, the reaction to the Holocaust, produced once more a new cycle of the protection of rights by which, by the time we get to the Warren Court, rights ideas have once more come to be a progressive notion. But that wasn't always so, and I wouldn't want you to leave here believing that some notion of rights, like the law of gravity, is what produced the protection of cultural minorities in the Warren Court. Quite the opposite. I'm suggesting that because the Warren Court had a descriptive and normative picture of the protection of rights, of the protection of minorities, they then incorporated this into a conception of rights for the first time in American history. So it's not that rights produce cultural diversity, quite the opposite. It's cultural diversity that gets interpreted in a particular way in terms of the protection of rights of cultural minorities. Now, I spoke of the citizenship cases, and now let me show you the flip side of the citizenship cases, because another of the most striking innovations of the Warren Court is the extension of the Equal Protection Clause to cover resident aliens. Now, before the Warren Court, you would be hard-pressed to find more than a handful of cases in which non-citizens were protected under the Constitution. Indeed, in the famous Chinese laundry case, Yicwo versus Hopkins, one of the really great examples in the late 1890s of anti-Asian sentiment in San Francisco, by which they really tried to put Asians out of business by putting Chinese laundries out of business on the grounds that they were in wooden buildings that were subject to fire. It's the first time the Supreme Court protected non-citizens under the Equal Protection Clause. And until that point, it was really a question of whether the Equal Protection Clause did extend to non-citizens. But that case, and just a handful of others, existed on the books when the Warren Court began its work. And it's at that point that you really see one of the really striking changes in the Warren Court's perception of the picture of the community. And that is, they extend the Equal Protection Clause to cover resident aliens who may not be discriminated against vis-a-vis citizens in the rights to jobs, to welfare, or to the provision of government services like schooling. It's a violation of the Equal Protection Clause to discriminate against resident aliens. That was almost hardly established when the Warren Court came into being. So now it's about time, I think, for me to address the issue of race and racial discrimination from Brown versus Board of Education on. Now, it's not as easy as one might imagine to translate from the race cases holding that state discrimination on the basis of race is unconstitutional, overruling Plessy versus Ferguson, 1896, which says that racial separation, apartheid, is not unconstitutional if the provisions of governmental services to the segregated white and black races are equal. It's not so easy to translate from Brown versus Board of Education into my broader picture of the emergence of cultural pluralism. For the narrow reason first that, as I said before, if you look at the underlying picture of the civil rights movement and of the attacks on racial segregation brought by the NAACP that culminated in the great case of Brown versus Board of Education, you have to say that it was based on a cultural ideal of assimilation. That is, almost all of the members of the NAACP in 1954, almost all of the lawyers in NAACP in 1954, and almost all of the judges who unanimously decided Brown in 1954 believed that in the not too distant future, blacks and whites would assimilate into one melting pot, and that race would become irrelevant in American society. How naive that seems to us today. How far from that cultural ideal we still are. So if we start with this qualification, you see that Brown versus Board of Education is not entirely a picture of protecting difference. It's based, I think, on an underlying cultural ideal of moving towards homogeneity. Nevertheless, Brown versus Board of Education is the premier example of a large number of Warren Court decisions that protect outsiders, politically weak, politically marginal, and scorned outsiders. Or in the famous legal language of the Carolyn Products footnote that inspired the Warren Court, it was a case of the court using the Constitution to protect, quote unquote, discrete and insular minorities. Now, these discrete and insular minorities, racial, religious, ethnic minorities, were what made the Warren Court famous. Extending the protection to scorned and marginal outsiders is what made the Warren Court famous. And I have to say, I think it was the only court in American history that actually sympathized and empathized with the outsider. In my book, I also attempt to show that the liberal judges of the Warren Court were themselves overwhelmingly from backgrounds that made them outsiders. And so they came from a position in which they had reason to sympathize with the outsider. And it is the protection of the outsider, I think, that ultimately spins out into this view of a cultural diversity and pluralism as an underlying value in American society. So that when the Warren Court sees that it needs to protect racial minorities, it also begins to think in terms of outsider religious minorities, or it begins to think in terms of outsider groups like aliens, or it begins to apply the Equal Protection Clause to illegitimates. The laws of many states had patently discriminated against children born out of wedlock, in which if a person who was legitimately born could not be deprived, say, under a parent's will of whatever he was entitled to in the estate, it was possible in most states for illegitimates to be totally cut off from the family wealth. Again, though you wouldn't think about this one way or the other standing alone as a question of cultural pluralism, when you begin to see it as one of the pieces and one of the dots of protecting a difference, of protecting outsiders, you realize again it's part of the tapestry of cultural pluralism that the Warren Court established. Indeed, when the Warren Court decides in 1967 that interracial marriage, miscegenation, that laws barring interracial marriage are unconstitutional, it too is a version of protection of cultural minorities. It's not only that they are saying that a white person has a right to marry a black person and vice versa, but they are also coming to terms with one of the real racist horrors, racist nightmares, and that is that there will be racial mixing and that the children of an interracial couple will produce, as it was often called in the racist literature, mongrelization. So it's also part of the view that an overlapping racial society in which people are no longer either one or the other, but both, is part of the American cultural tapestry. Now, moving to one other area that presents even, I think, further difficulties of translation, and that is the famous decision in Griswold versus Connecticut, first of all, for the first time in 1965, establishing a constitutional right to privacy, which becomes the basis for the abortion decision in Roe versus Wade. But in that particular case, which deals with the issue of birth control. So in Griswold versus Connecticut, the Supreme Court strikes down a Connecticut birth control law, which of course has religious overtones in all sorts of ways. Interestingly enough, birth control laws were originally an expression of Protestant Puritanism, and then by the time it was challenged in Connecticut in the 1960s, there were a few Protestants in Connecticut who were defending birth control, anti-birth control laws anymore. It was primarily being defended by Catholics. But in any event, this was an issue of the extent to which people would be allowed to develop a sphere of privacy separate from the state. And if you begin to think about the literature of cultural pluralism, going back to our friend Harold Laski, the British pluralist, you see how close the privacy decision maps onto earlier ideas about cultural pluralism. And that is, to the extent that you allow and encourage separate spheres that are independent of state control. You do that not only for private autonomy, but to promote cultural diversity. So the privacy decision, though it says nothing about cultural diversity whatsoever, is, it seems to me, clearly translatable into this Warren Court tapestry of encouraging cultural diversity. Encouraging, in other words, at a time when birth control might still have been controversial in some places, the opportunity for people to do what they do in their bedrooms, independent of either the view of the dominant majority or of state control. Now, it seems to me, finally, the most interesting problem of translation involves the decisions dealing with pornography and obscenity. In 1956, the Supreme Court decided Roth versus United States. Justice Brennan wrote one of his first opinions, a much criticized opinion, saying that the First Amendment rights of freedom of expression does not protect obscenity. And though the decisions spun themselves out thereafter, Justice Brennan was much criticized, especially in that case by Justices Black and Douglas, who had a more absolutist view of the First Amendment that they claimed did not allow the state to deal with obscenity. Justice Brennan held, to the contrary, that the First Amendment does not protect obscenity. And so, from the point of view of libertarians, his position was objectionable. Now, however one defends or criticizes that opinion, one thing is very, very clear. It was on the subject of culturally critical expressions, artistic expressions involving issues of sexuality. It was the most liberal opinion ever decided by the Supreme Court on that question. That is, when you see the way in which Brennan defines obscenity, you see how narrow his definition is. You see how much of artistic expression is being protected by his definition of obscenity. You see that at a time when censorship of movies, when exclusion of D.H. Lawrence's Lady Chatterley's Lover is standard practice in most states, that he's developing a conception of obscenity that doesn't exclude those controversial, sexually oriented artistic expression, and that in fact, as ultimately happens, the Supreme Court's obscenity decisions are very widely protective of artistic expression, and some would argue non-artistic expression as well. In any event, what I want you to see is the translation that I now give to the obscenity decisions. How does one translate the protection of artistic expression that once was easily excludable under censorship laws, that led to the end of movie censorship, for example? How does one translate those developments in the Warren Court, protective of free expression, into the picture of cultural diversity that I'm suggesting to you. Here it seems to me, again, when you realize that the dominant view of obscenity was a fairly narrow, intolerant, religiously derived view of what was permissible and what was impermissible, a straight-laced, puritanical view of what could be part of artistic expression, you begin to see that the Supreme Court is developing a more overlapping conception of artistic expression. And that is a view that, sure, there may be people who, out of their own views of what is legitimate, don't want to see movies or don't want to read books that they regard as beyond the pale. But nevertheless, let us understand that American culture should not be bound to an idea, a Puritan idea of what is permissible in terms of sexual expression, or what is permissible in terms of artistic conceptions. And that is, it recognizes for the first time a more cosmopolitan picture of what is legitimate artistic expression than anything that had happened before. So there it is. What I want you to see is the way in which during the Warren era we moved from a dominant picture of American society that descriptively assumed that it was relatively homogeneous, which descriptively assumed that there was a wide consensus about values, to a view of American society that, in Michael Walzer's words, develops spheres of loyalty, spheres of justice, overlapping and multiple conceptions of the arrangement of the society among different groups and different values. That's the descriptive level. And at the normative or prescriptive level, it developed a picture of diversity and pluralism as the strength of a free society, contrary, I emphasize, to the way it had been mostly among the Founding Fathers, certainly among the Jeffersonians, mostly among the people who resented mass immigration in the late 19th century, mostly among the people who had advocated a melting pot that would produce homogeneity once again. So both at the prescriptive and at the descriptive level, the Warren Court, for the first time, saw a cultural pluralism and laid the foundation for the multicultural society that is emerging. Thank you. And now I'd be happy to take questions on this or anything else.
Can you explain the rationale behind the Supreme Court's decision to make money the equal of voice in determining that you could use all the money you could lay your hands on? Was it a defense of property in the old sense, or was it a defense of artistic expression to allow the wealthy to control the political scene?
So I think it's totally appropriate that you should ask this question on this day, right? In which we had an election in which money played an unprecedented part in determining the election. The case you're referring to, of course, is Buckley versus Vallejo, and in which the court said that money is speech and placed a whole bunch of constitutional limits that may ultimately overthrow any attempt to have campaign finance reform, unless the money is speech doctrine itself is going to be questioned. Now, let us first and foremost say that the case was decided after the Warren Court had come to a close. So it's a Burger Court decision, not a Warren Court decision. See, there was Earl Warren, and then there was Warren Burger, okay? So now, it does seem to me quite clear that if we're going to have anything resembling serious campaign finance reform in which we're going to take the influence of money out of the election, in which we're going to try to reverse the process by which the United States Senate is a collection of millionaires, even in an era in which $1 million ain't what it used to be, in which somebody spends $60 million of his own personal funds to buy a seat in the United States Senate, in which we have, I think we're probably approaching something like half of the United States Senate of being the people who in one way or another have bought their seat by personal funds. Maybe this is the House of Lords in the age of wealth. So if we're going to reverse that, it seems to me very clearly there has to be a reversal by the Supreme Court of the view that I am entitled to spend my entire fortune as a matter of free speech to win an election. How the Supreme Court came to this view, I think, is what I have described in an article as the Lochnerization of the First Amendment. Now, a quick interpretation, though not an adequate one for those of you who don't know what I'm talking about here. Lochnerization refers to the infamous case of Lochner versus New York in 1905, by which the Supreme Court struck down a maximum hour law for bakers on the grounds that freedom of contract entitled bakers to enter into any contract they wanted in order to and to work as long as they wanted. But it gave birth to the notion that there was a so-called Lochner era that began in 1905 and ended in 1937, by which the Supreme Court used the Constitution to protect the wealthy and the powerful. What has happened in the last 20 years, 30 years, is that the Supreme Court has used the First Amendment freedom of speech provision in exactly the same way. More and more and more, you see that the First Amendment does not protect those outsiders who it was once designed to protect and until very recently were the main beneficiaries of its protection, but almost now more and more and more protect insiders, the powerful. It protects commercial speech. Now, for those of you who believe that this is an example of the even-handedness of the Supreme Court, maybe it is, but it is very interesting that in one era, the First Amendment protects the weak and the powerless against the government stomping out minority views, and in another era, it's deployed by the Supreme Court primarily to protect those who otherwise have enormous resources and power within the political process. So that's where I think the money is speech idea comes from.
Well, I don't mean to ask one more follow-up. Is there a theory by which you believe that that decision can be successfully attacked?
Well, I think I think it was always a mistake to think that we had an absolute right to freedom of speech. Okay, that is, we all know that falsely shouting fire in a crowded theater is not protected by the First Amendment. And there are various other examples by which we would agree that you need to balance the interests. So at the very least, without a deeper theory on this subject, I would say that it would be legitimate to limit if it is the free speech rights of a person to spend his entire fortune on buying a seat, we need to limit that for the purpose of assuring the integrity of the electoral process and of democracy. And at the very least, it seems to me, that ought to perform the theory.
This ought to feel familiar to you, Professor.
Aha, familiar face.
I think historians might ask about the Red Scare cases as a way of being curious about the difference perhaps between a commitment, both normative and descriptive, to political diversity and a commitment to cultural diversity. So I suppose my question is, where do those cases fit in your perspective on the Warren Court and the emergence of cultural diversity?
Okay. I think that's an excellent point. I think there's no question that the Warren Court decisions during the McCarthy era involving the Red Scare were, though slowly and gradually and perhaps overcautiously rendered, eventually developed into a view of the First Amendment as a major protection of political dissidents. As that happened, I think they gradually, as your question suggested, came to think more and more about the legitimacy of political dissent and political diversity than they once did. If you actually follow if you trace the history of the Supreme Court's tolerance of political dissent, you'll see that before the Warren Court, there are relatively few cases in which the Supreme Court invokes the First Amendment to protect political outsiders. So I think it's true that defense of political outsiders under the First Amendment gradually gels into an idea of political diversity. And that gradually translates into an idea of cultural diversity. And so, Aaron, as usual, you've kept me on my toes, and that's, it seems to me, correct.